what is the difference between a motion for reconsideration and an appeal? My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public. So please subscribe to our channel. We have these things come up, and sometimes people want to file an appeal or a motion for reconsideration. And a lot of times people don't know what the difference is. Clients will ask us, my lawyer has told me that I have these options. What do they mean? Well, I will tell you this. A motion for reconsideration, number one, goes before the same judge, okay? At the same level, same judge, based upon the same evidence. And it asks the judge to review a decision. It doesn't review a decision based on anything new. It reviews a decision based on what was there. It asks the court to reconsider. There's typically no oral argument. There's no reply brief filed. The court's being asked to look at what's already there. This is different from an appeal. An appeal is typically to a different court, like the Court of Appeals. It goes before different judges. It is different judges looking at the work that that judge did and determining, did that judge commit reversible error? Was there an abuse of discretion of some sort? Is the error harmless? Did it negatively impact the outcome of the case? These are things reviewed by a higher court, so that's a completely different aspect. Now, motions for reconsideration are quicker. They're quicker. The reaction to the motion for reconsideration usually comes way quicker than the reaction from the Court of Appeals. It's also less expensive. You're filing a quick motion. You're paying your attorney's drafting a motion, paying a filing fee. There's no oral argument. There's no nothing. When you go to the Court of Appeals, it's very expensive because the Court of Appeals has all these regulations about transcripts and briefs and everything that they require because they're looking at it brand new. In order for them to be boned up on the subject so that they can give an opinion, they need all this stuff brought to them, whereas the guy for the motion for reconsideration already has it in front of him. So the appeal to the Court of Appeals is a much more time-consuming, much more expensive process, and it's going to take longer to get a verdict. Oftentimes what people do is, before they consider the expense of an appeal, they'll ask the lawyer to file a motion for reconsideration on the hopes that maybe the cheaper way will work. Sometimes it does work. Sometimes there's a glaring error. Sometimes the court is on the fence on something. So you file a motion for reconsideration so that the court can look at it and maybe at a different time in a different light, maybe change their mind. Most of the time, though, historically speaking, percentage-wise, I think you'll find the motion for reconsiderations are denied for the reasons set forth in the prior ruling. And then you got no choice and you go up to the Court of Appeals. You have a certain amount of days from the time of the motion for reconsideration is denied to file a claim of appeal. So you got to follow those strict rules. Do you have any questions about that? Reach out. We'll be glad to help you out.
248-588-3333. 248